Hi, everyone. Okay, so today we're going to talk about the notice of motion and the affidavit that I submitted on February 10th and Owen Johnson's response and what the outcome was from that. Okay, so um, the notice of motion for the extension of time for the appeal. So um, this extension of time for the appeal I'm putting in is for October, the trial that occurred October 25th, 2022, which is for custody of my children. Um, I'm putting in that it violates my Canadian constitutional rights under Section 15.1 and 15.2 of the Canadian Constitution. It's discriminatory in nature, creates a situation where I, as a parent, am being denied access to my children. It's been 110 days since I've seen them. Um, Unreasonable conditions, creating personal and financial hardship, denies the children the right to learn about their mother's culture, religion, and belief system, denies the mother the right under the Human Rights Code, uh, the right to family, and it denies the children the same thing. Um, Creates a situation of financial exploitation. It has been over 90 days since I have been permitted to see my children. I've been denied complete access to my children since the weekend of November 5th, 2022. Sorry, I'm just going to, I don't know what's going on here. So this is the first page. You guys can read that if you want. Pause it and read it. Second page, which I'm reading from right now. While I've occasionally been in the city, I was under the impression I had 90 days to appeal. I am not a lawyer, and I asked for leniency and understanding on this matter. So I'm not a lawyer. I don't know court procedure or policies or anything like that. It's unfair for somebody who's being forced to self-represent to to expect them to know everything um, that lawyers know. I mean, lawyers go to school for what, 6 years, 4 years, something like that. And somebody who is self-represented is supposed to what, inherently know this information that the lawyers spent years learning. I mean, that's pretty presumptuous of the courts of Manitoba. So not allowing leniency on that something as simple as a time frame when there is clear evidence that there was a breach of somebody's constitutional rights, it really speaks volumes about the justice system and how the Manitoba family court system discriminates against individuals. Um, Then I go on to say in January, I received word that my oldest daughter was put into a medically induced coma and that that week almost died in hospital. Anytime I could see her, I spent time with my daughter, and I shouldn't be penalized with a denial of an application for an appeal for putting family first and needing more time to file my appeal. So that was my motion for an extension of time, which I had to file before filing an appeal. And since the motion for an extension of time got denied, I can't file an appeal. Okay, so this is my affidavit that was in support of. And we're going to go over this step by step so we can talk about it and what it means um, and everything. So, number one, the order made October 25th, 2022, Exhibit D, violates my rights as described in Section 1, 15.1 and 15.2 of the Charter of Rights and Freedoms Act, which is protected under the Charter of Rights and Freedoms, which is protected under the Canadian Constitutions Act of 1867 and 1982, which is Exhibit A. So we're going to talk about that for a moment. So we're going to skip ahead to Exhibit D, where I want to show you who was there. So, okay, so who was at the trial? Alexandra Aquila and Madison Parker, who was counsel for Owen Johnson. So Owen Johnson had two lawyers at this trial. Owen Johnson was there. Alicia Griffin, counsel for Winnipeg Child and Family Services. I'll talk about that in a minute. And Raymond Babb, supervisor for Winnipeg Child and Family Services. Okay, so now we're going to jump back to the Constitutions Act, which is Exhibit A. Okay, so as you can see, the Constitutions Act of 1867 and 1982, this can be found on, well, if you Google the Constitutions Act, you can find this exact document. Just click on the PDF version and you'll see it. Okay. So I'm going to jump back to that on my paper. Sorry, give me a second here. So the Constitutions Act speaks about the equality of rights. That's part of our Charter of Rights and Freedoms as Canadian citizens. As I mentioned in my affidavit, it's protected under the Canadian Constitutions Act, the act that our country is literally founded on. So let's talk about that for a second. So equality of rights. Every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, nationality, ethnic origin, color, religion, sex, age, or mental or physical disability. Subsection 2 says, 15.2, subsection 1 says, does not preclude any law, program, or activity that has the object amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, nationality, give me a second, ethnic origin, color, religion, sex, age, or mental or physical disability. So an organization like Legal Aid Manitoba is a law program that would fall under these criteria of a program that exists to create equality in the court system. So the fact that sorry, I'm kind of jumping ahead here, but this point is important because the next document that I'm going to show you is a letter from Justice Peterson. So keep in mind that that the Manitoba or Legal Aid Manitoba, the program Legal Aid Manitoba exists to create equality and equality in the court system. Okay. So number 2 in the affidavit. I wrote Justice Joel back in September 2022, requesting an adjournment of the trial scheduled for October 25th, 2022. I indicated that Legal Aid Manitoba would not be able to find me a lawyer in time for the trial. Justice Peterson wrote in a letter dated October 7th, 2022, which she indicated was on behalf of Chief Justice Joel, that the adjournment was denied to me. Please see Exhibit B. So we're going to jump to Exhibit B. Here it says, Chief Justice Joel has asked me, as the assigned case conference judge, to deal with this matter. Now, from my understanding, Chief Justice Joel oversees all the judges. From my understanding, I'm not 100% sure about that. But what I do know is that if an adjournment is requested, it has to go to Chief Justice Joel. Now, the trial judge is different than the pretrial judge. So the pretrial judge is Justice Peterson. So why Justice Peterson is weighing in on what is going to occur at trial, I'm not exactly sure. But it continues. I acknowledge receipt of your email dated September 26, 2022, wherein you are requesting an adjournment of the trial scheduled to commence on Tuesday, October 25th, 2022. I also acknowledge Ms. Aquil's letter dated October 3rd, 2022, advising that Mr. Johnson opposes your adjournment request. I also acknowledge the response set out in your further email dated October 5th, 2022. You will recall that Chief Justice Joel had previously refused your first adjournment request on May 4th, 2022. Respecting your trial schedule for May 10th or May 17th to 20th, 2022. Subsequently, for reasons set out in his letter dated May 13, 2022, he granted your second request for an adjournment of the trial. One of the conditions of the adjournment, as stated in his letter to you, was that the trial shall proceed no later than November 7th, 2022. Okay, so let's talk about that last paragraph quickly. So May 4th, I wrote Chief Justice Joel and asked for an adjournment. The reason being is May 14th, there was a case conference. April 14th, there was a case conference. Just a second. During this case conference, there were a few orders that were pronounced. First being that, so previously Owen Johnson, he attacked me. I was on muscle relaxants, painkillers, and anti-inflammatories as a result, also having to take some time off work. Police came, they attended the situation. They didn't take my statement for, it happened in September 2019. They didn't take my statement until January 2022. Or sorry, not 2022, January 2020. So that was like almost 6 months later that they took my statement, finally. It went to, but in September, it went to the Crown's, the Crown to determine whether charges were going to be laid or not. Charges were dismissed. Why? I don't know, but they were dismissed. Now, following that, in I believe it was October 2020, Owens Johnson's dad, Leonard Johnson, I don't know whether he bumped me or he pushed me, but what I do know is that I ended up on the ground with him hovering over me with a big smile on his face. Now, I had witnesses at the time that gave police their statements, and police were willing to charge him at the time, but I foolishly didn't. I mean, first of all, the guy's old, and second of all, he's my kid's grandfather. I mean, I should have charged him. I regret not doing it. But anyways, so So I ended up in physio for almost, well, over a year after that. I was in physio. I had cortisone shots. I'm still dealing with pain as a result from it. Um, and as a result, I don't feel comfortable around either one of them. But the order that Chief Justice, or sorry, the order that Justice Peterson put in place, even though I indicated this in my affidavit, she indicated that I'm supposed to go to Owen Johnson's house, or sorry, Owen Johnson's trailer, because he lives in a mobile park. Um, he, I'm supposed to go to his place of residence and pick up and drop off the kids with not only him, but his parents there, whom he lives with. So, two of my attackers, I'm supposed to go to their place and pick up my children, and I'm supposed to feel safe doing this? And Justice Peterson's comment is, well, you could do it curbside. Well, that's great. So what? You're going to let the kids run across the street? Like, I'm sorry, but and okay, that's not exactly fair because it is a mobile park. So I mean, like the alleyway is fairly close to the house. So literally, I open up the door to the car, and he's not even 6 feet away from me. So uh, I mean, it's an unsafe situation. Period. And the funny part about this is not really funny, but well, if you want to look at it as being stupid funny, then okay, fine. But um, Owen Johnson's parents, Leonard and Joanne Johnson, they put in their affidavit that they're scared of me. So they're scared of me. I'm scared of them, but I'm supposed to go to their house or their place of residence to pick up my children and drop off. Now, tell me how that is beneficial to the kids or even remotely in the kids' best interest. So, but see, it's my belief that she put that order in place because I indicated that I feel unsafe in that situation. And I believe that she's biased against me. So I got cost ordered against me for that order, and I'm being put in an unsafe situation. And my kids are being put in a situation where all the all the adults surrounding them are feeling apprehensive and scared in the situation, creating an unhealthy environment for the children. The second order she put in place that day is the property order, which we will discuss in length in probably the next video or the in the next few videos, because I was appealing that one too, and it also got denied. But um, following that, um, following these orders being pronounced, um, I mean the how illogical and how much hatred this justice must have towards me to be able to put these orders in place just it astounds me. Like I always believed that the justice system, it would prevail, it would be equal, it would be just, um but it wasn't. And when I guess when I finally realized that there wasn't any hope in hell in finding justice in this justice system, um, I hung up the phone at the case conference. I called Aaron, who was a parental assessor, or a family assessor from Family Dynamics. I, being a social worker, I recognized the fact that I was in crisis. I recognized the fact that I was in trouble, So that's why I reached out to her. Um, my doctor had previously given me some pills to help me sleep, and I started popping them. Now, I had considered taking the whole bottle, and it would have taken 30 seconds for me to do so. But I decided that that wasn't a wise idea, and I only took a few of them. And the emergency report can verify that. If I had wanted to kill myself, the hospital report would indicate otherwise. And um, me, who has worked in the healthcare field for a couple decades now, and well, prior to becoming a social worker, if I had wanted to kill myself, I wouldn't be sitting here right now. Okay. But my reward for reaching out for help and um, dealing with the situation as best I could was having my kids apprehended the next day and me being denied all access to them going forward. Um, my kids were not with me when this happened. They were with Owen Johnson. I would never have even remotely even thought of that if they had been there. I probably would have called somebody and tried to, if they had been with me, I probably would have put my focus more on them as opposed to, because I would have needed to probably called somebody to help me with them if I needed, but how things would have played out would have been entirely different. Um, but yeah, because I had literally had a medical crisis. My kids are now being denied to me, and they have being denied to me. Um, Winnipeg Child and Family Services, um, they discriminated against me based on medical, and they apprehended my children, and they refused to allow me to see them on numerous different occasions as a result. Um, and this is supported in Owen Johnson's affidavit, which I will be posting following this video. Okay, so moving forward, going back to the letter. Oh, and that is the reason why Child and Family Services were at the trial, even though Child and Family Services had a trial date scheduled for December, which Legal Aid found me a lawyer for the CFS matter, but the CFS matter, even though the CFS lawyers attended the custody trial, my CFS lawyer from Legal Aid refused to, because according to whatever clause or whatever conditions Legal Aid has, he was only able to represent me during the CFS matter. So CFS came, manipulated the family trial, literally ambushed the family trial, at to further their agenda. However, I was not permitted representation. I wasn't permitted a defense. None of that. All that was denied to me. And that was denied to me because Justice Peterson denied me the adjournment, which would have allowed me a lawyer through Legal Aid Manitoba. Yeah, so I'll continue and you'll see. As you will recall, Chief Justice, in his May 13th letter, also required you to provide proof of your medical diagnosis and seek medical attention forthwith, and provide proof that you've done so. I forgot to add one more thing. Going back to that last paragraph. So May 4th, I asked for an adjournment because it was literally May 14th that I had literally a medical breakdown. Um, following following that case conference, constant harassment from Miss Aquila and Owen Johnson, but primarily because of those orders. Um, but um, after so 2 weeks later, I mean, I had a medical breakdown. I'm not going to be better in just 2 weeks. There's just no way. Um, so May 4th, I wrote Chief Justice Joel, who refused to grant me an adjournment. Keep in mind, like a family trial, that's one of the most stressful situations any parent can be in. So for somebody to say no, that you aren't being granted an adjournment following a medical breakdown, which the sole purpose you had this medical breakdown was because of legal harassment, is kind of unreasonable. But regardless, it is what it is. So May 10th, my lawyer, Douglas Johnston, put in a request to withdraw as being my lawyer, and it was accepted. May 10th was literally a week before trial. So now I've just had a medical breakdown. The judge cleared or approved Mr. Johnston to withdraw as being my lawyer, which literally left me a week before trial, forcing me into a position where I needed to self-represent. Like normally, if from my understanding, if a lawyer tries to withdraw a week before trial, they're not normally allowed. But in this case, it was. And of course, it was Justice Peterson who, again, allowed it. Um, so I again, on May 13th, wrote Chief Justice Joel, and I pretty much said to him, and, you know, that if it, um, that Winnipeg Child and Family Services apprehended my kids because of a medical breakdown. And if they're saying that I'm okay to self-represent, well, then I'm probably going to end up doing that again. So he then granted the adjournment for the trial that was scheduled for May 17th to May 20th. But there was conditions on it. So that falls into the paragraph that I was reading. As you will recall, Chief Justice in his May 13th 2022 letter also required you to provide proof of your medical diagnosis and seek medical assistance forthwith and provide proof that you've done so. The only independent proof provided thus far is a copy of a doctor's note indicating that he is treating you and that you have a history of depression and anxiety. No proof of diagnosis or ongoing medical assistance has been provided. So, but those things contradict themselves. So she says that there's no proof of medical diagnosis, but acknowledges that my doctor sent in a note saying that I've got a history of depression and anxiety. Depression and anxiety is a diagnosis. Those are very real medical conditions. And then she goes on to say, or ongoing medical assistance has been provided. Well, it also says that the doctor's note indicates that he is treating me. I realized that it wasn't as detailed as maybe Justice Peterson would like, or maybe she didn't see the diagnosis she would like. But she isn't a doctor, and um, for her to say that I didn't provide the requested information, well, that's inaccurate. I there was a diagnosis there, and there was confirmation that he was treating me, which is what was asked for. Um, but there's also another thing to consider too. Now, say the doctor had been more detailed. Well, Owen Johnson would have had that information, giving him information to my medical information, which is a breach of FIA, the Personal Health Information Act. Um, it's a violation of my personal rights. So, I mean, and I wrote Chief Justice Joel saying, okay, well, if you need more information, I will gladly provide it. But I would ask that I receive something in writing stating that Owen Johnson or Miss Aquila would not be allowed access to it, because I mean that's my personal information. So, um, or maybe it was Justice Peterson I wrote. I'm not quite sure. I wrote one of them. So, anyways, um, in the next paragraph, in considering your third request for trial adjournment, I've assessed and contemplated any prejudice that may occur should a trial proceed, as well as any prejudice that occur should the trial be adjourned. In doing so, I have taken into consideration that it is in the best interest of the children and both you and Mr. Johnson that final resolution be determined at trial. I am concerned that your children remain under Child and Family Services apprehension. I also note that you indicated that you have been off work for over a year due to health issues and stress created by your case. So she acknowledges the stress, the depression, the anxiety is a result of the case, which is actually also in my doctor's note. It is regrettably not uncommon for litigants to experience stress during a family law proceedings pending the resolution of their matter at trial. In the circumstance of present case, a trial will be permitted or a trial will permit the custody and child support issues to be finalized. The result clarity should help alleviate stress for both you and Mr. Johnson. So basically, she understands that it could put an exceedingly amount more stress on me. She understands the fact that this stress literally almost cost me my life, and yet that does not matter. I note your advice that Legal Aid Manitoba may be unable to secure you counsel for your trial. I appreciate that it can be challenging for an individual to be self-represented. In that regard, however, I sent you the document Information for Self-Represented Litigants about Family Law Trial Procedure on May 10th, 2022. That I also know that while never easy, you have represented yourself at times during your proceedings that commenced in 2019. Yes, because I was forced to. A week before triage, my lawyer, Douglas Mayer, he withdrew from being my lawyer, and as such, Justice Peterson at the triage, even though I referenced the Constitution, denied me an adjournment for the triage. See, this is an ongoing thing with the family court system. I have a lawyer. They would draw literally a week before trial, or literally a week before some proceeding, and the proceedings happen regardless. Where I'm forced to self-represent, where I'm not a lawyer, I'm not prepared to self-represent, but I'm being forced into that situation. I note that on August 30th, 2022, you commenced a further court proceeding in the federal court on your own behalf against numerous defendants. Yes, I did. And I will explain that in a minute. It actually ties directly into this. I put a motion in for a claim in the federal courts because my rights under the Constitution Act were violated. Now, if this adjournment actually had been accepted, if this and the appeal had gone through, where the trial would have been reheard, the funny part is that federal claim probably would have become null and void, but they denied it. So now I I have a statement of claim against the federal government for literally, well, a lot of money, and asking for a few other things. So something that could have been resolved with a second trial or something is now might cost Canadians literally millions of dollars. Do you remember that case a few years ago where there was an immigrant who came to Canada? He sued the government um, for breaching his constitutional rights, and then and he won. And then he left Canada. It was a big uproar. Well, I figured if that's permitted, then why can't a Canadian citizen um, do the exact same thing? I mean, my constitutional rights were violated. As a result, I'm being denied access to my family, and um, and every avenue that I've taken in the King of Court's bench to try and remedy the situation has been denied to me. Miss Aquila has said, "Oh well, she should put in for a variance of the order." Well, okay, so the variance of the order, if I did that, you know what? No, I'm not going to talk about that right now. We'll talk about that afterwards, because um, I'll be talking about the implications of this order and everything, and that's where that can come in. So sorry. So I'm going to continue on with this document. Um, I note that your advice that legal aid may be unable to secure you counsel for your trial, even though I applied in May 2022. By October 2022, they still could not find me a lawyer, whether it be funding, resources, whatever. They couldn't find me a lawyer. And for that, I am being penalized. I appreciate that it can be challenging for an individual to self represent. In that regard, however, I sent you the document information for self represented litigants about family law trial procedure on May 10th, 2022. I also know that it's never easy. You have represented yourself many times proceeding commencing in 2019. I note that on August 30th, you commenced further court proceedings. Okay, well, I think I've already read this. Um, as you can hopefully appreciate, and as Chief Justice Joel suggested in his earlier correspondence, the court as an institution and its judges acknowledge the prevalence and profound challenges facing individuals struggling with health and financial issues and the inability to obtain counsel. That said, the court must also ensure prudence to the core function, that it retains a dispassionate discipline that will permit an adjudicative role to be carried out and exercised in a way that is fair to all parties. Okay, so let's think about this for a minute. So Justice Peterson basically, or Child and Family Services has literally robbed me of my family because they say that because they because well because I took some pills. Um, and even though the kids were never any danger, they're taking the stance that I have a mental disability or something like that. So that would fall into again into the Canadian Constitution, where I should be considered one of the protective classes. Um, However, Justice Peterson is also denying me that right by denying me um, the right to a lawyer. Now, I was a client of Legal Aid Manitoba. It is not my fault they were not able to find me a lawyer in time. That actually falls into the provincial government's realm, because maybe legal aid didn't have the funding or the resources, whatever it was that prevented them from finding me a lawyer, should have been addressed, but it wasn't. And as such, as a client of legal aid, I was penalized for legal aid not being able to find me a lawyer. And the way I was penalized was I was being forced to self-represent, even though Justice Peterson acknowledges it is um, how did she put it? Um, Even though she acknowledges it's a very stressful situation, um, I appreciate that it can be challenging for an individual to self-represent. So even though she understands that it can be challenging, she acknowledges the fact that I have anxiety. She acknowledges the fact that um, it could, well, it 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 has impacted me. Um, she is still forcing me into a situation where she's even though she's forcing me into a situation where I have to self-represent, putting me in an even more dangerous situation, forcing me into a situation where it creates even more stress. I probably am saying that horribly, but it is what it is. I've only, yeah. Um, so we're gonna go over this. Hang on a second. So we're on. Sorry, we're gonna jump back because this has been going on for a little bit, and I'm starting to run out of time here. I'll have to create a second video for this one. Okay, so number 3. I'm accused of having some mental ailment. At least that's what Child and Family Services used as an excuse to apprehend my children and deny me access to them. And why I and sorry, I am accused of having some mental ailment. At least that is what Child and Family Services used as an excuse to apprehend my children and deny me access to them. At least that's from my understanding. Why Owen Johnson got sole custody on October 25th, 2022. Child Family Services has not been able to provide me any documentation supporting their claim. Does it make sense that the courts of Canada is putting someone accused of having a mental condition in one of the most stressful situations a parent can be in and then forcing them to self-represent? As a social worker, that to me sounds like psychological and emotional abuse. If a parent does not have the mental capacity to make good decisions for herself and her children, is it fair for the court system to put them in a situation where they have to self represent and then, in turn, denying them their constitutional rights, which is discrimination? The section of the Constitution I am referring to and is provided in Exhibit A exists to create equality in the court system. And since this was denied to me, a fair and equitable trial cannot have occurred. So, the part that I'm referring to there is the equality of rights. And I believe we've already been over that, right? Yes. So, um, I'm just going to continue from here then. Okay. At the October 25th, 2022 trial, 3 lawyers attended representing Owen William Johnson's interests, and I was not even permitted a legal aid lawyer to represent me. Denied by denying me legal aid Manitoba additional time to find representation for myself. The argument might be made that Legal Aid Manitoba, an organization funded by the provincial government, had lots of time. They had from May 2022 to October 25th, 2022. However, they were not able to produce representation Is it the fault of the client, being me, or is it the fault of lack of funding and lack of resources from the provincial government? However, it is me who is getting penalized with being denied the adjournment for extra time for Legal Aid Manitoba, the ability to find me a lawyer. Evidence was submitted for the trial that was not included in the discovery period as set out by Justice Peterson. This evidence I have not been permitted a copy of, and I was forced to self-represent. If I am forced to self-represent, as which was indicated, then I should have been provided a copy of the evidence or been allowed to gain a copy of the evidence. Now, if you look at the court register, there is some evidence that is sealed. I can't gain access to it, and um, if I'm being if at this trial they considered me self-represented, then I should have at least been able to get a copy of it. The final order is illogical. At best, it is being viewed as discriminatory in nature, while stating that I should not be left alone with my own children, needing a supervisor. It inputs my income of that of a social worker. The income, from my understanding, is based on Owen Johnson's claim that I am capable of making a social worker wage. However, this logic means that I'm capable of working as a social worker. There isn't a social worker out there that doesn't work or impact the lives of vulnerable individuals. The final order forces me back into the workforce with the input of income to which independently or to work independently with vulnerable individuals from children to youth to adult. Yet I am being denied access to my own children and the right to parent them. While on Legal Aid Manitoba, I was not working, my income was inputted and support payments and back payments were ordered. At the time of the trial, I had not been working in over a year. This order creates a situation where financial exploitation is being allowed to occur. Also, costs were awarded against me in the sum of a full year's worth of what was inputted as my income. The final order indicates that I should be paying Owen Johnson back for child support for the time the children were under apprehension by Child and Family Services, hence, in Child and Family Services care. The apprehension occurred during a medical breakdown that was created by bullying and harassment by multiple hearings and orders that should have been dealt with at the trial, hence Owen Johnson and Alexandra Aquila were the main people in the harassment. Although Justice Peterson was a party too, because she could have easily said, you know what, this is harassment. So we're going to jump to Exhibit C. I'm trying to rush through this because my videos, they only give me about an hour, and then okay, so Exhibit C. So this is a doctor's note from well, a doctor. And it reads, due to medical issues, specifically acute stress stemming from family legality issues, this patient will be required to take time off work. And then it gives some dates, but I've gone back numerous times since then. Okay, so this doctor pretty much says, well, he gives a diagnosis, and if you look at this doctor's note was given to the courts in, I think it was September of, well, no, sorry. This doctor's note was given to the courts in 2021. It would have been. So, I mean, the medical diagnosis also is supported with this doctor's note. The courts have gotten multiple doctor's notes since then. In all reality, I think they even got access to some of my medical file, but um, which I don't believe is ethical because it gives Owen Johnson the right to that as well, um, which is why I think it is unethical. I don't know if they got access to it, but um, I know I gave one of my, I know I gave a lawyer access to it, so I don't know if he shared it or not. Um, Regardless, um, let's go back to the affidavit. So it shows the impact that this case has had on my health. Um, Child and Family Services made a predetermination prior to the Child and Family Services trial that was scheduled for December 2022 that I would not be allowed access to my children, hence medical discrimination, and to which they have yet to prove that I do have a medical ailment or that such an ailment would impact my parenting. So, um, during all this, Winnipeg Child and Family Services actually told the courts that if Owen Johnson got sole custody, they would close the file. So even though I would technically still be in the children's life, I would no longer be considered a danger to them if I was ever even considered a danger to them. But so CFS used their power to manipulate a family trial with no real medical information, no real medical diagnosis, or anything else. All they had was that I experienced depression and anxiety. And for that reason, my children got ripped away from me and denied to me. Now, I understand that there was a medical crisis. I totally get that. But you know what? I dealt with that, and they should have been looking at reunification. But instead, again, that was denied to me. Um, Child and Family Services attended the family trial October 25th, 2022, as a way of circumventing the legal process and promoting their own agenda. I did have a lawyer who was willing to attend the December 2022 trial to deal with the Child and Family Services matter. He told me I stood a good chance at getting my kids back. However, he had been retained by Legal Aid Manitoba to represent me, or he had not been, however, he had not been retained by Legal Aid Manitoba to represent me in the family trial. So he could not attend to defend me as the matter would be scheduled for a different court date. So, sorry, this is what I'm reading. I'm trying to go through this a little bit quicker because I only have a few minutes left on this video. Um, but you can read it over yourself as well. By allowing the family trial to proceed in a manner in which it did, created a situation where I was discriminated against and denied a fair trial in both matters. I did not have a criminal, I do not have a criminal record. I do not have a child abuse or adult abuse record. I am presently working as a social worker with children, youth, and young adults, yet I am being denied access and the ability to parent my own children. So that was my affidavit, and um, I hope it gives some people a little bit more clarity on why I am creating these videos. Um, if anybody knows, there is something out there called the Millennium Scoop. or millennial scoop. It is a term that has been thrown around um, in the last, I don't know, few years, maybe more, where CFS agencies are coming in to apprehend children. Um, a lot of it is Indigenous people are still highly represented, overly represented in the ratio of apprehensions in Manitoba or even in Canada. Um, but I would suggest that the millennial scoop also includes um, people who have experienced some sort of medical breakdown, or people who with any sort of mental disability or ailment. I would suggest that CFS is using their power to manipulate family trials. I would suggest that CFS is creating a situation where um, they're acting as a superpower and circumventing the legal process and um, to further their own agenda, and where discrimination is being actively supported in Canada. And realistically, CFS files are pretty well impossible to gain access to. So for somebody to make a claim and or to find out what exactly the lawyers have said, or sorry, um, the CFS workers have said against them is next to impossible. You need a lawyer for that, and if you're a self-represented individual, it's almost impossible to actually get access to those files or to have any sort of equality in the court system. Um, on that note, I am going to say goodbye to you guys for the moment. In my next video, I will be talking about Owen Johnson's response to my motion for an extension of time and my affidavit.